Well, hello, everyone, and welcome to One Civil Law. I hope you're having a great day. As always, I'm your host, Kurt Mueller, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story, we turn our attention to a fitness company that sues a YouTuber over a mean review. This fitness company sent the YouTuber a product to get a review. The YouTuber did not like the product, and the company wishes to sue over them not liking the product because they think that they make the bestest product, don't you know? And any wrong opinion must be a misstatement of fact. It must be defamation. I thought we stopped this stuff with the Consumer Review Fairness Act from a couple years ago, but companies are still trying this, despite the fact that it's, just people saying, I didn't really care for your product very much, and here's some reasons why I didn't care for your product very much. I don't think it's a very good product. But, you can't have the wrong thing. I sent it to you in the hope that I get a good review, and not so much. And so I'm going to sue you over the bad review. Seems a little excessive, but what we're going to do. So we're going to review this stupid lawsuit for all of its glory and watch a company, whine about someone not liking their stuff, over the page for a while. So let's go ahead and do that. We are in the United States District Court for the Western District of North Carolina. We are in federal court between Vulcan Strength Training Systems and Gluck's Gym. Gluck's Gym does reviews of products. Didn't really like Vulcan's products, apparently, and Vulcan is sad. Okay, let's read about their sadness. Plaintiff Advanced Fitness Concepts, doing business as Vulcan Strength Training, by and through its undersigned counsel against defendant Adrian Gluck and Gluck's Gym, allege and state the following. This is an action for injunctive and monetary relief based on defendant's publication of false, unfair, deceptive, and defamatory statements about Vulcan and its products in violation of federal and state law. Sure it is. Defendants are in the business of posting online video reviews of fitness equipment. That is one of the things that Gluck's Gym does with its time. Yes, they review products. They hold themselves out as providing an in-depth and honest review, which what the hell does that mean? What does it mean to provide an in-depth or honest review? But receive compensation from major fitness equipment manufacturers when the reviews generate sales. Well, I assume that they have affiliate links to various things, so I guess. Defendants persuaded Vulcan, a small veteran-owned company, nice to throw the flag in there, just stand behind the flag at any opportunity you have. The designs and sells equipment to send them at no charge, Vulcan Talus all-in-one gym for review. Okay. It's like, we'd like to review your product. Could you send it to us, please? We'd like to. And the company's like, okay, we'll send you the product so you can review it. Cool. Rather than producing a good faith review, defendants published a highly negative video which intentionally made false, misleading, and deceptive statements about the product. Sure it did. And made gratuitous, disparaging remarks about Vulcans and its products. Well, they don't like your product very much, and I don't think this is helping. They might think your products suck. They also might think that you as a company suck. These are legal opinions. I don't know what to tell you. Defendants produced this incendiary, negative review of a small company's product to bolster defendants' reputation for honesty without endangering their revenue streams from large manufacturers. Sure. Despite Vulcan's request, defendants have failed to withdraw or correct their defamatory video, resulting in lost sales and profits to Vulcan and irreparable damage to Vulcan's customer reputation and goodwill. Well, I think Vulcan's pretty much got that covered by suing, someone because they didn't like their review very much. The Vulcan therefore brings this action to halt defendants' ongoing tortious conduct and for appropriate monetary relief. Plaintiff Vulcan is a North Carolina corporation in good standing. Sure. Defendant Gluck is a citizen of Connecticut. Defendant Gluck has a limited liability company in Connecticut. Upon information and belief, Gluck's Gym was owned and operated by Gluck. Sure. We'll assume that there's jurisdiction and venue for the moment. Although, to be honest, that's not necessarily clear in this situation. So we could get into an interesting thing over jurisdiction and venue, okay? And because Gluck is in Connecticut, not North Carolina, okay? So the company wants to turn around and sue Gluck in its home territory. Okay. Now, can they do that? Well, we know, or we may remember from the Toddy Without a Crystal Ball case that merely publishing comments on an open forum like the World Wide Web does not create jurisdiction everywhere. You need to do something more specific. You can go to the U.S. Supreme Court case of Calder, which, as you remember or may remember from the Toddy case, is the most illustrative case on point on this issue about when you can sue in someone or something. So one of a couple things has to happen. Either the publication has to happen in North Carolina, which it presumably didn't, because presumably he made it from his house in Connecticut. So the publication didn't occur in North Carolina. It occurred presumably in Connecticut. So that doesn't work. And then if you don't have the publication itself in the jurisdiction, then you need to establish sufficient minimum contacts in order to sue there, which requires Gluck to do something specific to avail himself of North Carolina, more than just posting things on the web that people in North Carolina can see. He needs to do something specifically to bring himself into the jurisdiction of North Carolina, which is not at all readily apparent. So first thing I would be thinking about if I'm Gluck would be thinking about whether or not I can challenge jurisdiction here, because I have a pretty reasonable basis to think that I could. So Calder being our case in point, we could fight that, but we'll ignore it for the moment as we press on. Okay. All right, Vulcan and its products. Vulcan's founded in 2008 is a 100% veteran-owned company and registered as a small disadvantaged business with the United States Small Business Administration. I don't care. That's great. It doesn't matter. Vulcan designs and sells Olympic-class weightlifting equipment, cross-training equipment, home gym equipment, and commercial gym fitness equipment. Over its 17 years of existence, Vulcan has built an excellent reputation among customers for high-quality products and superior service. For example, Reviews.io, an independent customer review aggregation site, reports that Vulcan's average rating among more than 3,400 customer reviews is 4.8 out of 5 stars, and 96% of reviewers recommend products. Well, I mean, that's great for you, Vulcan. I'm really happy that apparently 96% of your customers like your products. That's super duper good for you. So you should be pretty happy about that. That doesn't mean you can sue the remaining 4%. I'm sorry. The 4% that don't like your products, I don't know what to tell you. You're just going to have to try harder, or, sell something or else, or I don't know. But you can't sue people because they don't like your stuff. Mr. Gluck is apparently one of the 4% that doesn't like your stuff very much. I'm not sure what this random appeal to popularity is doing here. Like, that makes any legal difference. Who cares? Right? I mean, 99% of people can like your product. If I'm the one guy who doesn't, oh well. Sorry about that. I guess I don't know what to tell you, man. I don't know. Yeah. Among Vulcan's products is the Talos All-in-One Gym, a universal gym that provides mobile strength functions within a single frame. So akin to the Total Gym, I guess, from Chuck Norris days, or something comparable at least. Launched in December 2023, the Talos product has been well received by customers and reviewers. Great. Good for you. For example, Garage Gyms, an independent review site, published a thorough review on August 31st, 2025, and concluded the Talos is an excellent piece of equipment, checking a ridiculous amount of boxes on just about any garage gym checklist, and is well thought out in terms of what features to include, what materials to use in order to provide both safety and longevity, and how to price it to remain competitive. Well, again, I'm super happy for you that Garage Gyms apparently liked your product. That's their prerogative. Apparently, they, along with 96% of your customers, thought you made a generally good product that people might be, recommended to buy. Gluck's Gym isn't feeling it, though. I'm sorry that, all the ladies love you, but not this one. You can't sue their way into Gluck's heart. It's not going to happen, man. Sorry. Defendant's business. Defendant Gluck's and his company, Gluck Gym, provides video reviews of fitness equipment. These reviews typically feature Gluck on camera describing the product. Sure. Defendant maintains a website at glucksgym.com, which says that defendant's business strives to provide in-depth and honest review on well-tested items. Cool. In addition to posting reviews on their website, defendant also posts the reviews on YouTube, Instagram, and other platforms. Upon information belief, defendants realize advertising revenue. Sure. I mean, we all do. From posting things. Yes, that's true. Defendants also maintain a presence on Patreon, an online monetization platform that allows creators to run a subscription. Patreon users pay monthly to view content. I'm waiting for the point when I care. Upon information belief, defendants have agreements with many fitness equipment manufacturers to pay defendant compensation when defendant generates sales as affiliates. Sure, that's probably true. Yeah, I mean, he probably does have affiliate deals with lots of companies. In fact, I understand that he has an affiliate deal with you, although he doesn't like this particular product. So that means he's willing to spite himself in his own financial interest to say, I don't like this product. So even though he's an affiliate of yours, it's like, this product isn't doing it for me. So he's willing to sacrifice his own revenue, which is a pretty good sign that, he's giving reasonable reviews or thoughtful reviews. Okay. Defendant's engagement with Vulcan. Some years ago, defendant applied to Vulcan to become an affiliate and entered into an agreement, which provided, among other terms, defendant would receive compensation on sales. Vulcan would, in its discretion, provide defendant with products for review, and defendants would avoid slander, misrepresentation, or disparagement of the products or reputation. Well, I will kindly remind you that once again, in 2016, the United States Congress passed the Consumer Fair Review Act, or the Consumer Review Fairness Act, which, among other things, prevents companies from including in their contracts provisions that would restrict someone from providing a negative review. You can't do that, right? A lot of companies were trying to do this, like hotels and car makers and whatever, right? A lot of companies were doing this. Slipped a provision in their contract that says you will not say mean things about our product. And then when people said mean things about it, they sued. And Congress got so pissed, they made it illegal to do that anymore. So to the extent your contract is itself attempting to prevent Gluck from saying mean things about you, your contract is void because it's illegal now. Sorry. So there's that. Defendants were not particularly active as Vulcan affiliates until July 2024, when Gluck began communicating with Vulcan CEO about obtaining the Talus all-in-one product. Gluck persisted in requesting the product, sure, making a renewed request in October of 2024 and January and May of 2025. Sure, whatever, fine. In initiating pursuing these contacts with Vulcan, defendants knew that Vulcan was located in Charlotte. Oh, that's what you want to do? That's how you want to get jurisdiction to this thing? That is not going to work. That is not going to work. Oh, they reached out to us in North Carolina to get the product for review. Therefore, there's jurisdiction for the mean words. Get bent. I don't think so. I have a hard time believing that the courts in North Carolina are going to go for that theory of jurisdiction. But I do love your attempt to get creative. Oh, because they reached out to us in North Carolina, they reached into our states and purposely availed themselves of it. Uh-huh. Yeah, if I'm Gluck and Gluck's attorney, I'm thinking very seriously about challenging that bullshit. Yeah, I'm not sure about that one, but you do you, Vulcan. As a result of these communications in early 2025, Vulcan shipped the Talus product from its warehouse in Charlotte to defendants at no charge. As configured by defendants, the product had a retail value in excess of $4,000. Super duper. After receiving the product, Gluck had mobile communications with Vulcan about assembly. Among other things, Gluck stated he was missing parts. Vulcan had advised that the new and improved parts were on order, and before as soon as they received them. So they shipped a product that was missing things. Well, that might, somewhat hamper the review. When you shipped me the thing, it didn't have all the parts I needed to put it together. Now, the company wants to make it right, I suppose, by sending the parts he's missing, but it's not exactly a great sign they were missing in the first place, you know? That might tarnish the review a little bit. Gluck also identified some issues he was seeing with the product, including concerns about the assembly instructions and the tautness of the cables, but acknowledged that it had not been fully tested due to the missing parts. But he said, like, so far I'm having these issues. So he's like, okay. In response, Vulcan resent a full copy of the assembly instructions, including 4 detailed schematic pages and a 6-page step-by-step guide, and pointed out the virtual 3D model showing every detail of the product was available on Vulcan. Okay. With respect to the tautness of the cables, Vulcan advised that standard cables are intentionally designed with about 1.5 inches of slack, but because customers have different preferences, Vulcan ships shorter cables to any customer that prefers them at no charge. In a follow-up call, Gluck stated the existing cables were fine and there was no need to send shorter cables. Well, he wants to review the product as you configured it. So it's like, yes, we will do this. We will send you different cables, but if he's going to review the product as you send it to him, and he finds during his reviews that those cables aren't to his liking, then he has the right to say it. Now, the fact the company would make it right by sending different cables is neither here nor there. The product as he received it had these defects, even if the company is willing to fix it in some way. You know, ideally, you want the product to be perfect when it arrives, right? The fact the company is willing to switch out parts is, you know, yeah, I mean, maybe that's not satisfying or could hamper their review in some way. In mid-August, Vulcan learned the new parts would be delayed longer than expected. Again, this might hurt the reviews a little bit. I love it when Vulcan, in their own pleading, starts telling me reasons that Gluck may not necessarily be thrilled with their product. That's how we know we're off to a great start, guys. When you read the complaint, which is written by Vulcan in their voice to be as favorable to them as possible, because of course it is. Of course Vulcan is going to make themselves look as good as they possibly can. Why wouldn't they? Why wouldn't they try to make themselves look as good as they can? And when you're reading their complaint, and in their own complaint, they start specifying reasons that Gluck may not have been a fan. Oh, it was missing parts. Oh, I didn't like the cables it came with. Oh, the replacement parts didn't come when you said they would. You know, when you start listing things that might influence his review negatively, it's like, oh, these are some reasons. Oh, okay. Yeah. Vulcan advised the delay and offered defendants could either continue to wait or alternatively, they'd send someone to disassemble and remove the equipment, and the parties could try again later once the upgrade parts had arrived. Vulcan responded by inviting Vulcan to retrieve the product, saying, I don't have any way of shipping, or I do that. Well, you know, whatever. So he might have some thoughts on the product as it was retrieved, as it was sent to him. So if he was unable to complete a full review of the product because of missing parts or whatever, guess whose problem that is? That's Vulcan. Are they going to try to turn around and accuse him of providing a less than full review due to missing parts they failed to send? You should have waited for a full review. Well, I wanted to review what you sent me, and what you sent me left something to be desired. So I told people about that. That's not fair. That's extremely fair, Vulcan. No. All right. Despite the above agreement to put the project on hold, which, by the way, is not even what they said, right? What agreement to put it on hold? Was there an agreement to put it on hold? That's not what you said, right? You said they offered defendants could either wait for the parts or alternatively send someone to disable and remove it, and the parties could try again. He said, well, pick up your stuff. He never agreed to put everything on hold. You apparently inferred something that was not promised. It's like, well, either, you know, you can wait for the parts or we'll retrieve our stuff and you can wait. So you can retrieve your stuff, but he's not obligated to wait. He has no obligation to you. He has no promise to you. You sent him the stuff free. You don't even have a contract with him because you sent him a gift. right? He solicited the gift, but that doesn't matter. You can solicit a gift. He said, hey, Vulcan, how would you like to send me a product for free? And Vulcan's like, yes, I would like to do that very much. So that's not a contract because Gluck isn't giving anything. Gluck isn't offering anything. Gluck is like, how about I give you nothing? You give me some equipment. And they're like, okay. So he solicited a gift and they sold the gift. There was no promise of any description. There was no obligation on his part. Yeah, no, not so much. This is falling apart. This is not going great. Despite the above agreement, which there wasn't an agreement, even if there was, there's nothing to bind the agreement because it's not a contract. Within 10 days, defendant publicly posted a video called a 60-second gym tour in which Gluck briefly showed the product and called it a pile of shit. Well, first of all, pile of shit is his opinion. That's an opinion. It could have nothing wrong with it, and he still thinks it's a pile of shit. That's just an opinion. I think this Lamborghini's a pile of shit. I think this Ferrari's a piece of shit. I think this Bugatti is a pile of shit. And whatever, right? I mean, okay, noted. All right. Less than 2 weeks later, defendant posted on Patreon a 12-minute video titled, I just killed the Vulcan Talos and maybe Vulcan 2. The Patreon video was only available to members who subscribed. The defense also posted a free teaser on their Instagram page. Sure, great. Shortly thereafter, defendant posted the same video on their YouTube channel under the title, This is the worst product I've ever reviewed. That sounds suspiciously like an opinion. The YouTube posting is freely available. Defendant video opens with an image of the Talos product in flaming trash bin. That sounds like an opinion. It then shows Gluck on camera, who proceeds to make intentionally false, misleading, and disparaging statements, I'm still waiting for those to happen, by the way, about the Talos payment and the Vulcan as a company, including the following. Gluck provides an extended rant about tension in the cable, saying they have too much slack. Okay, that's his opinion. He dismisses Vulcan's explanation that customers have different cable preferences with an expletive and say, this is awful. Okay. I mean, fair enough. Vulcan apparently said, we're doing it because this is what we think customers want. Gluck's over here saying, no customer wants this. This is some bullshit. I mean, who cares? It's an opinion. It's an opinion. Nowhere does he disclose the Vulcan sent shorter cables to all customers on request at no charge. He doesn't have to. He's reviewing the product as he received it. Or told customer in advance that sending shorter cables was unnecessary and the existing cables were fine. Well, even if he told you that, he has the right to change his opinion. Maybe he changed his opinion. Maybe he said the customer service was fine, or by fine he meant he was going to review it as is. Or maybe he just didn't want to tell you his opinion yet. Maybe he lied about his opinion. So sorry about that. That's sad. That's really sad. Gluck claims the video with grooves of pulleys are too small for these big, thick cables. The cables are 5 millimeters in diameter and the pulley grooves are 9 millimeters wide, providing a proper fit. It's his opinion. It's his opinion. In his opinion, the grooves are too small. You try to respond with, hey, the cables are 5 millimeter and the groove is 9. Now, I will agree with you that 5 is smaller than 9. I will agree with you as to that fact. But whether or not they're too small for the groove is an opinion. Right? I mean, he thinks that. You think it's the right amount. Cool. That's presumably why you designed it that way. You've designed it that way because you think that's the right number. He disagrees with you. He doesn't think it's the right number. He thinks another number would have been better. I don't know what to tell you. Gluck falsely asserts the user can't adjust cable tension from the trolley. Well, did he know how to do that? Was it in your instructions? Does it say how to adjust it? Does it provide how to adjust it in the instructions? You think that's a false statement of fact, really? Seriously? Get lost. Gluck states that Vulcan's directions don't say how to install the rear crossmember, causing him to install it upside down. The crossmember only has holes on one side, so it can only logically be installed one way. Well, apparently not. Apparently, he installed it upside down. You think your product can only be installed one way. Apparently, he disagrees with you. And it's I actually did install it the other way, and the directions were unclear. And you're like, that wasn't the way to do it. The only way was to do it this way. He apparently was able to succeed in installing it upside down. So I guess your claim that it can only be done one way is false, because apparently he was able to achieve the impossible. That's nice. Gluck complains that Vulcan's assembly instructions are incomplete, but comprehensive instructions were emailed to him. Well, I suppose he has a different view of what comprehensive looks like than you. He doesn't think they were comprehensive enough. He thinks the instructions left something to be desired. I mean, he does review gym products for a living. So first of all, he doesn't need to have a well-informed opinion, because people can have uninformed opinions, as you well know. So first of all, he doesn't have to have an opinion that's informed. But to the extent he does, he has a well-informed opinion. And he found your instructions to be confusing. Sorry about that. Maybe other consumers do not find it to be confusing. Maybe lots of consumers find it to not be confusing. He found it to be confusing. That's an opinion. Do you understand how opinions work? Gluck falsely claims the lat pull-up door doesn't fit properly. It does when it's properly assembled per the instructions. Well, that sounds suspiciously like, again, maybe your instructions are not all that. Gluck asserts it's not possible to use band pegs with the product, which is false. They offer them as an accessory. Okay. Gluck says the low row function is too low, calling it the world's lowest low row. Some competing products have a lower row, such as one offered by Rep Fitness, which the defendant reviewed favorably. First of all, no. Second of all, that sounds hyperbolic. When he called it the lowest low row, I'm not sure that you can interpret that to be literal. I'm not sure that he necessarily intended to be understood literally, as opposed to this just happens to be really particularly low. But apparently there's another one that he reviewed favorably. Now, maybe he reviewed it favorably for reasons that are independent of the lowness of it. Right? Maybe it is in fact lower, but there's some other countervailing factor about it that makes it desirable. Right? But this particular one didn't have the countervailing factor. So yes, in a different occasion, we'll take it as a given, although that's assuming a lot, but we'll take it as a given that on some prior occasion, he reviewed one that had a lower row as being good. He may have said it was good for countervailing reasons that were able to sufficiently offset the lowness of it, while yours didn't have those factors. So the lowness on yours was irritating, even though it wasn't irritating on theirs. You see how that could be possible? No, you don't see how that's possible? All right, well, think about it and get back to me. Each of the statements, as well as others throughout the video, were objectively false. No, they're not. And upon information, beliefs were known to be false. No, they're not. Are alternatively made without reasonable basis and fail to exercise ordinary care. Get bent with your lawsuit. Your lawsuit is done. In addition to the objectively false statements, which none of these are, Gluck, one of them may be, but even then, not so much. Gluck also made many gratuitously disparaging statements. Well, he's allowed to say mean things about you. He's not allowed to defame you, but he is allowed to disparage you. Sorry, but he is. He is allowed to disparage you. gratuitously even. Are you going to sue for IIED? That'd be hilarious. Are you going to sue for negligent infliction of emotional distress or intentional infliction of emotional distress? Because his statements were so gratuitously bad. They hurt your fifis. Do you want to sue for IID or any ID? That'd be funny. That'd be hilarious. Please don't try. Lol. All right. In addition to these objectively false statements, which no, Gluck also made many gratuitously disparaging statements, including calling it the world's worst website, 1, hyperbolic, 2, opinion, with low-res, grainy-ass pictures, opinion. Gluck calls the ordering process the worst experience I've ever had, opinion. Gluck says Vulcan's pulleys demonstrate every single thing you could do wrong and felt like shit, opinion. Gluck says the lap pull down was there's no way it could have done worse, claiming it's one thing, there was 47 or so things wrong. Hyperbolic, opinion. No. Gluck concludes by saying, if I was one of the people that spent money on this, I'd be pissed. Wow. Yeah, your lawsuit sucks. Your lawsuit sucks. Your lawsuit is bad and you should feel bad, Vulcan. Your lawsuit is bad and you should feel bad. Here's an opinion. Your lawyers are also full of shit. Yeah, and your lawyers are saying some bullshit in federal court. How about that for an opinion? Yeah. Defendants' motives. Upon information and belief, defendants have active affiliate relationships with rogue, rep, and other manufacturers, including, incidentally, yourselves, as you mentioned earlier. They have affiliate deals with you. These relationships create a dilemma. Strictly speaking, no. What you meant is a conflict of interest, not a dilemma. But that's okay. I'm here to help. These relationships create a dilemma because defendants' appeal in the marketplace depends on cultivating a reputation for fearless, hard-hitting reviews, but negative review of products with large manufacturers would impact their revenue. I am willing to bet, without looking, that Mr. Gluck has said negative things about large manufacturers' products from time to time. I am vaguely familiar with his channel. I've seen a few things on it. I'm not a connoisseur of his work. Nevertheless, I'm willing to take a flyer and assume that he has from time to time reviewed products by Rogue or Rep or other big companies and said, you know what? This isn't really doing it for me. I'm not feeling it. Just a guess. Yeah. Defendant's solution was to fabricate a negative and incendiary review of the product of a small manufacturer. No one cares how small you are, enabling defendants to portray themselves as crusaders while protecting the competitive interests of dominant companies in the industry who generate most of the revenue. Get lost. The video about Vulcan's Talos product, you know, did you really write your product in all caps? I'm really surprised at this point, every time you write Talos, you're not doing a little TM next to it. Or a little circle R, depending on whether or not you actually took the time to register it. Because you write it in all caps, so you're using it as a brand. I'm surprised that you haven't TM/R'd this thing every chance you get, just to show how great you are. Yeah, that's great. The video about Talos explicitly pursues this strategy. Gluck falsely asserts he's been the target of legal claims in the past due to his reviews. When in fact, the legal documents he briefly flashes on screen do not evidence any claims to manuals or proceedings. Well, if it was a false claim in the past, it's not now. So even assuming arguendo, in the past he said he's been sued. So we're going to sue him. What? Okay. He then proclaims this video won't make me money. I'll lose money, a lot of it, so go subscribe with his super subscribe link. He concludes by claiming the Talos review will lose me thousands of dollars, which he offers as badge of integrity. Well, I suppose that much is true. He's going to lose it in legal fees. Although if he needs someone to represent him in North Carolina, I'm willing to file a pro hoc. Call me. First, I'm going to shove cold air up their ass. Second, I'm going to explain to them how opinions work. Mm. When defendant posts Talos review on YouTube, Gluck pinned a text comment that appears prominently on the page. It read in part, yes, this video is a bit energized. Sure, it could have been a bit more professional. Whatever. But I don't work for these companies. I work for the viewers. I hope you'll find it helpful, concise, and fair. Also subscribe because this has been stressful. This statement is false and misleading. How? Because defendants do, in fact, work for Rogue. Wow. That's nice. He works for them because he has affiliate deals with them. Wow. That's a colorful way to characterize it. Exciting. Sure. Even if that's a false statement, by the way, it's not a false statement about you. So no one fucking cares. So fuck you. This statement is false and misleading because defendants do in fact work for Rogue Rep and other large manufacturers, and incidentally, by that logic, also work for you. So he works for you, so he's your employee. So responding at superior or something. As long as we're being stupid about this thing, right? And other large manufacturers, the defendant derives substantial revenue from favorable review of the products on his company. Defendant nonetheless explicitly holds their attacks on Vulcan as products as evidence that he doesn't work for these companies writ large. Okay. Impact of the conduct. Defendant's false and misleading review. A false review has been widely viewed by the consuming public, including potential customers. For example, the video, again, this is how they're going to try to squeeze jurisdiction out of this thing. Just in case the he contacted us in North Carolina argument doesn't work. Oh yeah, they're going to try to say there's been a lot of traffic in North Carolina. Hey, Gluck, Caldair's your friend. Shove it up their ass, or I'll do it for you. Either way. Potential customers have in fact been misled by defendant's false and misleading representation, with a large number of commenters of YouTube commenting Gluck for his supposed honesty and willingness to put integrity over profit. Defendants knew and intended, their false and misleading Talos review would cause substantial harm to Vulcan and its reputation and customer goodwill. Jesus Christ. How salty can you be, Vulcan? He's just not into you. He's just not into you. I'm really sorry, okay? Look, I don't know what rom-com fantasy you have in your mind, but Vulcan, you can't run up to his, window with a boom box, or whatever, run to him and catch him at the airport, or whatever rom-com fantasy, and you certainly can't sue him into loving you. I'm pretty sure that's not how that works. It's not going to happen, man. I'm sorry. It wasn't meant to be. Love is hard, man. Oof. This is the worst spurned lover lawsuit I've seen in a while. Vulcan is doing their best pick me impression, and they are really, really sad that they didn't get picked. This is desperate, man. This is sad. Defendants knew and intended their false and misleading review would cause substantial harm to Vulcan and its reputation. As evidenced by the title, defendant gave the video when it first posted. I just killed the Vulcan Talos and maybe Vulcan too. Many online commentators of the video expressed negative views about Vulcan and its products based solely on the misrepresentations. Well, if they didn't have reasons not to like you before, they do now. Because of the expense of a universal home gym product like the Talos all-in-one gym, most customers will have no opportunity to independently test the product. Okay. False and misleading representation of act under the Lanham Act. Well, I do appreciate them bringing the Lanham Act into this. As a longtime IP lawyer, I obviously did most of my career in patent law, but I do love me some Lanham Act. It's great. So I do appreciate Lanham Act being their first case out of the point. That's where my probably would go to as the Lanham Act, because I want that federal hook. So that's how we're going to try to get past this. Okay. So we're going to sue them under federal question jurisdiction, or try to sue them under federal question jurisdiction to get past the issue of diversity jurisdiction. So that's how we're going to try to solve that problem. So that we're going to do as a federal question to get past the diversity issue. First of all, I'm still shoving Caldera up their ass. Second of all, no, but that's fine. Defendant's false and misleading video about Vulcan's Talos product constitutes commercial advertising or promotion. Sure. And defendants were acting to advance their commercial relationship with Vulcan's direct competitors. The video misrepresents the nature, characteristics, and qualities. They don't like your product. As a direct review of the product, they've suffered harm, will continue to lose sales, otherwise its reputation with consumers and trade has been impaired. Well, I don't know if it's so much over the product review as over this bullshit lawsuit. Too bad you can't sue over that. Or you could sue yourselves, I guess. You could sue your own lawyers, Vulcan. You could try that for malpractice. That could be fun. From bringing this reprehensible and destroying lawsuit stupid. I would love to represent Gluck on this. I would shove their own products so far up Vulcan's ass. It'd be great. Right up their ass. The amount of damages is not reasonably capable of precise assessment, but will be provided specifically a tribal. Sure. Defense continue of going, blah, blah, blah. Defamation, So we're suing under state law in North Carolina for defamation, so we'll go look up the state specifics of defamation. Then we'll look up and see whether or not North Carolina has an anti-slap, and then we'll see whether or not we can actually use it in federal court or not. But we can do all those things. It's fine. The falsehoods communicated by defendant in their videos tend to impeach Vulcan in its trade or profession or otherwise subject to ridicule. They knowingly publish false and defamatory statements. They knew the statements were false. As a direct and proximate result, Vulcan has suffered harm. The continued lost sales, blah, 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 blah. Vulcan, through its attorney, made a written request that they would fail to withdraw. Okay, so that must be a North Carolina specific thing. Some states require that you give like a written opportunity to cure before you can sue. So either that's a North Carolina specific thing, or they did it anyway, for a belt and suspenders approach. But yeah, that's probably why that's there. They probably had to. Okay, so they sent you a notice and they still ignored you, so fair. But defense have failed to do so. The conduct above is ongoing, will continue escalating, blah, blah, blah. Unfair, deceptive trade practices under North Carolina state law. No. Unfair, deceptive trade practices. That's just hilariously not happening. That is really not happening. Deceptive trade practices? For a mean review in which they said mean things about your product? Really? God damn, man. How desperate are you? It's just, this reeks of so much desperation. Just give up your lawsuit. Give up now and try to pretend the whole thing never happened, man. That's some free legal advice to Vulcan right now. Damn. Defendants' conduct above was in commensurate effect, commerce, and sales. Sure. Defendant's conduct as above constitutes unfair deceptive acts? No. As a direct and proximate result, Vulcan has suffered harm and damages, blah, blah, blah. The amount is not reasonably capable, but exceeds $75,000. That's our diversity jurisdiction hook. So we're going to try to do that. Defendant's conduct above is ongoing, will continue. Defendants have willfully engaged. Common law unfair competition? Absolutely not. Defendant's false and misleading video about the Talos product constitutes unfair competition in violation of common law. And the defendants falsely disparaged Vulcan and its products in order to advance their commercial relationships. Absolutely not. You think they did it for that purpose? Do you really think that Rogue or Rep or anyone else saw that review and be like, boy, oh boy, we want to do extra business because of this review? Do you think that like your product just lives rent free in everyone's head? Or do you think Gluck's reviews live rent free in everyone's head? Do you think the boardroom of Rogue is having a meeting, emergency meeting to review this desperate thing? And they're like, oh my God, wow, we really want to do you really think that? Man, no one cares about your products, Vulcan. Aren't you guys veterans over there? Shouldn't you guys have thicker skin? Didn't you guys fight wars and stuff? You seem pretty thin-skinned, man. I'm not known for having particularly thick skin either. So I don't know if this is like the pot calling the kettle black or it takes one to know one, but either way, God, you guys have some thin skin. Jesus. Defendant's false and misleading video has in fact deceived. As a direct and proximate result, Vulcan has suffered harm and damage. It lost its continued sale and profits in excess of $75,000, which we want to do for diversity. I'm going to shove Caldera right up their ass. Defendant's conduct above will continue causing irreparable harm. No one should have harm. Issue a preliminary and permanent injunction. You're not going to get any of those things. Be ordered to publish a retraction. You're not getting that either. Order to file and serve upon Vulcans a written counsel under oath, setting forth the manner in which defendants have complied. We're not doing any of that. Vulcan have recover actual damages. You don't have actual damages. Vulcan have recovered damages by sustained by reason of defamation. No. Vulcan have if you make it past a motion for summary judgment, I will be slightly amazed. I'll be slightly amazed if you make it past a motion to dismiss. You might make it past a motion to dismiss, although I wouldn't count on it. If you make it past a motion for summary judgment, though, that would be truly amazing. I don't think so, man. Also, kind of, I really hope that it kind of, doesn't make it past dismiss so that I can, depose your people about your fifis. I look forward on behalf of Gluck to depose your people and ask you about your feelings and how they were hurt by the mean words. Where do the mean words touch you on the body? You can show me on the stall. It's okay. This is a safe space. They sustained by reason or Vulcan required damages pursued by law. Punitive damages? No. Vulcan recovered damages, actual damages suffered by reason, unfair deceptive? No. The unfair deceptive trade practices? No way. Yeah, I don't see that making it past a motion to dismiss. No. Yeah, I'm not really sure any of this is making it past a motion to dismiss. This is dumb. Recovered as damages sustained by reason, exceptional. This deems it to be an exceptional case. Okay, sure. It's exceptional. Right. Recover reasonable attorney fees? No. All costs, blah, blah, blah. Signed, Roderick Eanes. Well, Roderick Eanes, on behalf of Eanes and Archer LLP, Roger or Roderick, yeah, your lawsuit sucks. Your lawsuit sucks, and your law firm sucks, and you're bad, and you should feel bad for your stupid lawsuit. That's an opinion. Go suck it, Roderick. Yeah, so, well, that's the end of this stupid. So Gluck has some pretty good defenses. First of all, they've got a decent jurisdiction fight for the diversity stuff. They can shove Galtair up their ass. They're trying to use federal question jurisdiction to get past that. I'm going to point that out. I'd point that out in a motion to dismiss. If there is an anti-slap and I can use it, I'll shove that up their ass. And even if there's not, I'll basically do it. I'll do it the hard way. I'll just create one basically and try to shove that up their ass. So, this, also we want a jury trial. Okay. Yeah. We want a jury trial for this. Great. Yeah. I look forward to you guys telling this to a jury. Maybe we can bring the product into the courtroom and you guys can assemble it. Or, we'll bring in someone neutral. We'll bring in someone neutral and have them assemble it from the directions, and we'll see how well that goes. Maybe we can do a show and tell for the jury, with your glorious product. Have some people try to assemble it, see how well it goes in the courtroom. There's a lot of fun opportunities we could have here as we're thinking about how this could develop. But I think Gluck has some pretty solid defenses, mostly rooted in I'm an opinion. This is an opinion and get over it. Mostly being and also the as hyperbole for the air stuff. Someone says North Carolina doesn't have anti-slap. Yeah, either way, that's fine. If they don't have it, even if they did have it, I might not be able to use it, but they don't have it, that's fine. I'll just pretend it exists and kind of do it through a motion to dismiss. I mean, all an anti-slap is basically a special motion to dismiss. So I'll just basically do it in a non-special motion to dismiss. I'll just, basically do all the anti-slap stuff I would have done anyway and just do it in a motion to dismiss. So I can still kind of get there, but I just get there a little bit. It's not as great because the anti-slap affords me more expedited remedies and also attorney's fees, which are not available. But, that's okay. And I'll probably say it's frivolous and try to get attorney's fees that way because this is pretty dumb. So all that stuff Yeah. Maybe a Lego expert to assemble it. Yeah. So all that good stuff. So Gluck, if you need help, let me know. I can pro hawk into North Carolina or something. Otherwise, I'll be watching this case for all of its extended stupid glory, because this sounds like some utter bullshit. And also they themselves basically undermine their own lawsuit in their own complaint, which is pretty hilarious. So basically, I'll just quote their own language back at them and shove that in their face for a while. So I'll be good. And then I'll sign, what's his name? I'll send, what's his name? Roderick? Hold on. I think his name is Roderick. My browser has decided to stop working on me. I'll send Roderick some, salve for the hurt, so that it'll stop hurting as much. All right, well, that's been fun. I look forward to seeing whatever response gets filed to this. If it's me, I'm definitely going to be, mocking them in my response. There's definitely going to be a little bit of, sarcasm and a little bit of mocking them in my response as part of it, whatever. So we'll see, and we'll see how it goes. Could be fun. But either way, I've been Uncivil. Hope all's well for later, my friends. Cheers for now, my friends, and goodbye.